Hello and welcome to our estate planning webinar. I apologize. If you are just joining us, we're getting started here. We're going to give it just a couple minutes to let everybody join us. I'm also going to put a link to download our estate planning workbook in the chat so that you do have that you can download there. And I just want to make sure everybody's able to hear me okay, if everybody's able to see the presentation. If you can put in the chat where you're joining me from, maybe the city that you're joining us from, it'd be awesome to see. Okay, again, if you're just joining, go ahead and make sure to download that estate planning workbook as we are going to be working through that. Perfect. Okay, let's go ahead and get started. So my name is Crista Hermance. I am an estate planning attorney. Our firm is Hermance Law. You might know us online as Estate Planning Mom, Estate Planning Dad. This is our awesome team. So I started the firm about 10 years ago as a new mom. It was really important to me to have that balance between being able to be a mom while also being able to be an attorney. And so this is what has come of our firm over the last 10 years. It's just a very family-oriented practice. Okay, so I'm going to go through the agenda that we have for today. So I'm going to share some real-life scenarios with you. These are situations that I have seen over the years. These are cases that I think really help bridge the gap between what estate planning is and who can benefit by doing estate planning rather than having to have some of these issues that have come up. I'm going to talk about what probate court is. If anybody has any experience with probate court, I'd love to know that. If you can put that in the comment, just probate or court, it helps give me an idea of kind of what your experience is in having to deal with probate court. We're going to talk through that estate planning workbook that I have put in the chat for you to be able to download. I'll talk about the discount you get for completing a trust plan with moving forward with us, those next steps to get started. And if you stick around until the end of this webinar, you will get a free advanced healthcare directive. So that is something that I will share the link for you for. Okay. So to get started, and again, I'm going to just re-download the workbook in there for you. Just in case you weren't able to get it before, maybe you joined a little bit late. Let me put that in there so you can re-download that. Okay, so 4 things proper estate planning could have prevented. The first case is involving an investment account and divorce. Now, this was a case where my client's sister passed away and we had to go through probate court. And as she's gathering all of the assets for the estate, she finds this investment account. So she contacts the investment company and finds out from them that the money has already been distributed to the beneficiary on the account. And so she's confused because she is the only living heir to her sister. Her sister wasn't married, she didn't have children. So she wasn't really sure what had happened. And so I called them and come to find out that her sister's ex-husband was listed as a beneficiary on this investment account. And he just received it after sister's passing. And they had been divorced for over 22 years. And so my client couldn't figure out why her sister would have wanted this. And what we think happened was that when they had gotten divorced, in that marital settlement agreement, it said that this investment account was hers, but she never updated the beneficiary designation from him. And so maybe she just thought, it's showing mine in the divorce. There's nothing else I need to do. So if you take nothing else away from today, is check your beneficiary designations on your accounts, insurance, life insurance, retirement accounts, investment accounts, bank accounts, and just make sure they are all aligned with your strategy. And if something were to happen to you, who would you want to receive those? Okay. I will say for this one, that investment account, the beneficiary, the ex-husband, he did get over $300,000. And that is something that could have absolutely been avoided had proper estate planning been done. Okay. Okay. Next one is minor children and life insurance. So this was, I was working at a community event and I was standing at our table and this woman comes up to me and she's got two little girls with her. And as we're talking, she says, I recently lost my husband. I said, I'm so sorry to hear that. How are you doing? And she says, well, for whatever reason, he had this life insurance policy, but he didn't list me as the beneficiary on the insurance policy. He listed my minor children. And I said, I'm sorry to hear that. How is it going for you? And she says, well, for whatever reason, I now have to go to court to get guardianship over my children to be able to prove to the life insurance company that I have guardianship over them. And so I can't get access to the money until that's completed. And, I asked her if she was moving forward with that. And she said, at this point, I don't have the mental capacity to even start, right? To have to go through that process and to go through the court stuff. And so she had this very large life insurance policy that she was unable to touch. And as we're talking, I asked her, I said, did you guys ever do your estate planning? Do you have a will or a trust or anything? And she says, it's something that we always had on our to-do list, but we had never gotten to. And this is a really great example of how estate planning, one, isn't put as a priority for people, right? They know that they need to do something, but it's just something that they never actually move forward on. And then the second one is that had they moved forward, that strategy of that life insurance policy and how, if dad had passed away, how would he want that money to go to wife or to kids? Because there's a lot of misconceptions when it comes to life insurance and having minor children listed as beneficiaries. In this exact example, mom didn't have access to any of that money because she wasn't listed as a beneficiary. It went to the girls. And so this is something where estate planning could have prevented that type of situation that mom had to go through. Okay. Okay. Next one we have is adult sibling in parent's home. So this is a case where, and it is a very common one where, adult siblings, their parents pass away and all they own is a home. In this case, daughter calls me and she says, my mom passed away. It's just me and my brother. We get along great. Is there something that you can do just to transfer title from the home from my mom to me and my brother? And I said, let me do a little bit of research on the property and I'll get back to you. So as I get back to her, unfortunately, I have to tell her, because mom owned the property in her individual name, she didn't have a trust. We now have to take this house and put it through the probate court process to be able to have it distributed according to the probate court's plan, and then be able to distribute it to you and your brother at the end. And so it took 10 months on this case, which is pretty quick, actually. It ended up costing them about $18,000 in probate fees. And at the end, they were able to receive this house. Had mom had a trust, right? And this was the home, I think the fair market value might have been somewhere in the 700s. Had mom had a trust and had that home in her trust, that story would have gone a lot different. We could have got it done in a fraction of the time, at a fraction of the cost, and not have to go through all of that stress of having to go through probate court. And I think that this comes up so often with families where, when a parents pass away is, well, what do we do with the house? And not realizing that, estate planning needs to be done to prevent it from having to go through probate court. Okay. Okay. Last scenario to share with you is involving the blended family and the unintentional disinheritance. So in these situations, because we hear so many stories about blended families, right, where there's a remarriage and somebody passes away and now everything now goes to the remaining spouse, and everything, when that spouse passes, everything goes to that child of that spouse. Well, in this case, my client, her mother, she was the only child. She had a great relationship with her mom. She got remarried very late in her life. And She passed away very unexpectedly, no estate planning documents in place whatsoever. The mom, really her biggest asset was the family home, right? This was the home that my client had grown up in. And for whatever reason, her mom, after she had gotten married, now added her new husband to title of this property. She had no attorney information, like no advice as to what was going to happen as a result. And this is where I say it was an unintentional disinheritance, because by adding him to title, she unintentionally disinherited her daughter, right? Her daughter had now no claim to the house, and husband got it. And she had to fight for it. And it took years and a lot of money that was spent, a lot of emotion that went into all of these proceedings. And she did end up settling, and she got a small sum of money. But it was, had mom done proper estate planning and, whatever her wishes were, if they had been updated with in writing what it was, then it would have been something that my client would have known. But in this case, it was, she didn't believe that mom knew what she was doing when she added him to title. Okay. So this is why estate planning is so important. Okay. So let's talk about what happens when you have a plan in place and when you don't have a plan in place and something happens to you. So, when we think about it, there's kind of three different areas that we look at, right? The first is involving guardians. If you have minor children, please put kids in the chat. I'd love to see, who here has minor children. Okay, so when it comes to guardians for minor children, so under the age of 18, what happens is if something happens to both parents of the children, then generally you would have somebody, either family members or close friends, that would petition the court for guardianship of the children. The problem that you have here is with no plan in place is you have people that are petitioning the court. You have a judge that is making a decision where they have absolutely no input from you as to who you would actually want to raise your children, right? Because you never completed a guardian nomination. There's no will. There's nothing in place that says if something happens to me, here's who I want to raise my children. So you have a judge making a decision based on the evidence that's placed in front of them with no input from you. They don't know you. They don't know your family. They don't know your kids. They don't know the situation. And that's why it is so important to have some type of legal documents in place, because that is your voice, right? When you no longer have one. The next thing that we look at is incapacity. So when we think of incapacity, it's somebody lacks the mental ability to understand that if I do this or if I sign this document, the result that will happen as for signing it. So it comes into play whether it's for medical decisions or for financial decisions. Sometimes we see incapacity with people maybe that have a stroke or have dementia or have Alzheimer's, right? They don't have that mental capacity to understand what's going on when it comes to those financial and medical decisions. So here, what needs to happen is what we would call a court's conservatorship. And this is where somebody would petition the court for conservatorship over the person that is incapacitated. And the reason that you may need to do this is, well, what if there's a home in their name and you need to sell the home? What if there's bank accounts that you can't access that you need to be able to access, or medical decisions that you need to be able to make, right? So somebody petitioning the court for that conservatorship, the court is then going to appoint somebody to be in that role. Another problem that we have here, same kind of issue, is you have no input because no legal documents have been done that say who you want to be in this role. And so now you have somebody that is being appointed by the court in this role that you may not want. And so that is one of the issues that we see is it could be somebody that, will generally cause family strife, right? Maybe it's somebody that maybe wife wants to be the conservator over husband, but then one of the kids that doesn't get along with wife wants to be it. So now there's this family fighting in court. And so this can be prevented by having plans. The last thing that we look about is when somebody passes away. And so here is where you have what we would call probate court. So any assets that somebody owns in their individual name when they pass away. This does not include beneficiary designation. It does not include anything where there's joint ownership at a property, maybe joint tenants with right of survivorship. So any property that's jointly owned where by what we call operation of law, it just automatically passes, right? But it has to be held jointly. So it's any of those assets. those assets then would have to go through our probate process. And probate court is the process that allows you to say, okay, here's all of the assets that are in the estate. We file a petition with the probate court. And now, as we're going through the probate court process, we have to send notification, we have to get a bond, we have to get property appraised, we have to put publication in the newspaper, gather all of the assets, potentially sell the assets depending on what they are. And then as we continue through that process, pay any creditors, any bills that come up. And then once the court says, okay, everything looks good, you can go ahead and distribute. Then at the end, that's when those assets would be distributed to the heirs of the estate. The problem with probate court, and generally when people want to avoid it, is because they understand what's involved. And some of the reasons they want to avoid it is, one, it's a long process. So probate court in California can take anywhere from 1 to 2 years, and that is uncontested. That's just the time from somebody from the time that they file that petition in the court until that time that money is being distributed. It could take up to that long. And in some court cases that I've seen throughout the state, it's longer. You're looking at potentially 2 to 4 years. It's a public record, meaning anybody can go to the courthouse, pull the documents, and find out what you own, who you owe money to, and who your beneficiaries are, right? So there's no privacy when it comes to probate court. And the last thing is that probate court is very expensive. And to give you an idea, let's say that there's a gross estate with a fair market value of $490,000. With a gross estate worth $500,000. And let's say that it's made up of a home with a fair market value of $490,000. And so when I say the home and the value, it's not how much money in equity you have. That's a misconception, right? It's not the equity, because the house could be completely underwater. But from a probate estate, we're going to look at how much is the house actually worth, that fair market value of what it would sell for. That is the value we're looking at. And then let's say $10,000 in various bank accounts, so total estate worth $500,000. Those statutory fees, so this is set by the state of California, would be $26,000 for a $500,000 estate. In addition to those statutory fees, you also have filing fees, probate referee fees, bond fees, publication fees. That's another $2,000 to $3,000. That's almost $30,000 for a probate estate to go through probate for $500,000 estate, right? That's a lot of money. And this can be avoided by having a trust, right? A trust is going to avoid probate court if those assets are put into the trust properly. And we're going to talk more about trust planning, okay? The last thing to consider when it comes to probate court is minor children. So again, minor children in the state of California can't actually inherit money or property. And so if they're inheriting anything from an estate and they are under the age of 18, that money is going to go into a court blocked account where they won't actually get access to it until they turn 18 years old. And for some life insurance policies that I've seen, that's a lot of money for a young adult that probably isn't financially responsible enough to be able to make the right decisions on how to use that money. Okay. If you have any questions at any point, please feel free to put your questions in the chat and I will try to get to it. I do see some coming in. Thank you for that. And we're going to jump into the next one. If you're just joining us, please make sure to download the estate planning workbook. I'm going to put that in the chat for you. And then we are going to move on to just a quick diagram of what probate court is. You're going to find a copy of this in your estate planning workbook. It's going to be right after the table of contents. So if you are visual, it kind of just gives you kind of a workflow of what probate court looks like. Okay. One of the big things to remember here is either having a will or not having a will. It doesn't matter, right? If there's assets that have to go through probate court, having a will isn't going to avoid them, right? It's having a trust that would avoid probate court. Okay. Okay. So I want you to think, and I'm not going to ask you to share this, but I want you to think about what is your asset level at right now, right? Home, bank accounts, investment accounts, retirement accounts, anything that doesn't have a beneficiary designation. What is the value of your estate? Because we're going to talk about what would your estate statutory fees be if your estate had to go through probate, right? And would you be okay with the estate paying that much money, or would you prefer to do something else to protect it? Okay, so think about that, and then you can write it down or think it in your head. Please don't share it with us. I just want you to be able to have that level in your head of what your asset level is at. Okay. Okay. So the 5 planning documents that we're going to go through: power of attorney, advanced healthcare directive, HIPAA authorization, a will, a trust, and guardian nominations for minor children. Okay, those are the 5 areas that we're going to cover. So the first one is the power of attorney. The power of attorney is a legal document where you give an agent the ability to make financial decisions on your behalf if you are unable to do so. Going to the post office, going to file tax returns, pay the mortgage, right? Anything that if you didn't have the mental capacity to be able to do, your agent would essentially be able to step into your shoes and be able to act on your behalf. This is something that is so important. It is such an important document to have. A lot of times people come to us where they need assistance, but unfortunately the person doesn't have capacity at this point and they are not able to sign this document. So super important planning document to have. Okay. In California, we have the ability to do what's called a springing power of attorney. And so what this does is this allows you to say, well, right now I'm in good health, and so I don't need to be able to have my agent acting right now. I only want them to be able to act if something were to happen to me. So I only want my power of attorney to spring into effect upon incapacity, right? So we have the ability to do that in California. When you are identifying your agents, and this is where you're getting into the workbook, you're going to have spots to be able to put who you want in those blanks. It's important that you identify a primary and then 2 backups if you can. If you're married, your primary agent may be your spouse. They don't have to be, but they can be. And then having 2 backups behind that primary. The only requirement here is that they are over the age of 18. But anybody in this position, you want to make sure that they are financially responsible, right? They're going to be able to pay bills for you. They're going to be able to take action. They're going to be able to step in and do the things that need to be doing. Okay, question that just came in. What about non-springing? So we wouldn't necessarily call it a non-springing, but the idea is that when you sign the power of attorney, if it doesn't have the language saying it's a springing power of attorney, then it is just effective immediately upon signing, which means as soon as that power of attorney is signed, that person that is the agent can then go act on their behalf. They don't have to be incapacitated. The other issue that I see, oh, thank you, Gina. The other issue that I see is sometimes people, and I've had clients in the past that have come to us where they got their estate planning done at a different firm. They came to us to redo their plan. And as I'm going over the documents with them, I say, did you know that your power of attorney is effective now? It's not springing. And they had no idea that that was even a thing. They didn't assume that it was effective now. And they were really caught off guard knowing that those agents had the power now. Luckily that they were never used to their knowledge, but it was something that they didn't know. And so that's a really important thing is to know when it is effective. Okay. The other thing that I will mention with power of attorney, because this is another really big misconception that I see with people, is people think that a power of attorney is effective when somebody is alive as well as when somebody dies. And that is not true. A power of attorney essentially shuts off when somebody passes away. And that's where other estate planning documents come into play, like a will or a trust, right? So the power of attorney is only in effect when somebody is alive, right? It doesn't matter if they have capacity or not. And it also might depend on the language in the power of attorney. Sometimes I've seen language where people will just do it online and there's specific language in there that will say that it's only effective during this, during these time periods, or a durable power of attorney. And so if there's some type of change in healthcare and their mental status, it may no longer be effective. So it's really important to understand what type of power of attorney it is. Okay. Okay. Question is, can a power of attorney deny the settler from having surgery? So a power of attorney is specific to financial decisions. So specific to healthcare is going to be related to an advanced healthcare directive. It's not a power of attorney for financial decisions. They are 2 different things, and we're going to switch to that one next. So if you have any other questions on power of attorney, a lot of great questions that have come in, please feel free to put those questions in the chat. And we're going to move on to the advanced healthcare directive, right? Similar to the question that was just asked. So the Advanced Healthcare Directive is what we call it in California. Some people might know it as the living will or power of attorney for healthcare decisions. These are different documents. They do different things. And that's what a lot of the estate planning documents are. Because when you think of estate planning, it's not just one thing, right? I'm going to talk about 5, but there's many other things that are in a comprehensive estate plan. Every single one of these documents are needed for different situations that may arise. And so the Advanced Healthcare Directive allows you to identify an agent to be able to make healthcare decisions on your behalf if you are unable to do so. Very similar to the power of attorney for financial, but this is specific to healthcare decisions. In addition to those agents that you're identifying, and again, I recommend having 1 primary and 2 backups, is there are certain end of life decisions that you're going to include in your Advanced Healthcare Directive. And remember, if you stick around to the end, I am sharing that link for you to be able to get a free Advanced Healthcare Directive. So, but the end of life decisions, so, do you want burial? Do you want cremation? Would you want any type of organ donation for transplant purposes, or would you want none at all? If you were in a persistent vegetative state, would you want to be kept on prolonged life support with extreme measures, or would you want to be taken off? Right? All really important healthcare decisions. Those are documented in your Advanced Healthcare Directive. Without having proper documentation, your family may be shut out from being able to make decisions or even be able to get information as to what's happening. A lot of times, people don't think about this, but if you have an adult, a young adult child, if your kid turns 18 years old, at the time they turn 18, you are shut out from being able to make healthcare decisions for them, get information. And so this is a document that we have that we help clients get for their kids, especially if they're going away to school, right? Because you want to make sure that you always have the ability to have access to their medical information. If they're hurt and they're in the hospital and they can't say, yes, I want you talking to my parents, this would allow that. In addition to the Advanced Healthcare Directive, there is what's called a HIPAA authorization. The HIPAA authorization doesn't allow somebody to make decisions, but it allows them to get information, talk to doctors, and really not be shut out from that protected healthcare information if something were to happen to you, right? So both of those documents are important documents to have. Again, for this one, primary could be your spouse, doesn't have to be, but then having those backups as well. The recommendation I would make for this one is when you're choosing your agents for this, it could be the same agents as your power of attorney, the financial stuff, but it may not be, because maybe the skill set for those agents that are the financial people don't have the same skill set for making these really tough decisions, right? Being in these stressful situations with the emotional side that's happening. If somebody's sick or dying, what's going to happen? Your people. You need to choose people that are going to be successful in these roles, because if they can't act or they don't want to, then they can say, I'm not doing it, right? There's nothing that says they have to act just for putting them in there. So with any of these roles, it's important that you make sure that you are checking with the people to make sure that they are okay acting in these roles, okay? Okay, any questions on the Advanced Healthcare Directive or healthcare questions? I'm going to start heading over to the next one, which is the will. So a will is probably the most famous when it comes to estate planning documents, right? We see it on the movies. It's the reading of the will. And the will is a legal document in which you give certain instructions to be carried out after you pass away. In your will, you can say how you want your assets distributed. It allows you to nominate guardians for your minor children. Once somebody passes away, that is when a will is filed with the court, thereby making it a public record. If somebody in California passes away and they do not have a will, California has an estate plan for you. The legal term is called intestate succession. And it basically says, this is what your family tree looks like. This is how your assets are distributed. It may be how you would want it distributed, but it may not be, right? So that's why having a will, having a trust are important estate planning documents. The biggest myth I hear with wills is people say, oh, I have a will, it's going to avoid probate court. I don't need to worry about getting anything else. And that is not true. A will alone will not avoid probate court. If there are assets that need to go through probate court, a will is basically just going to tell the court, here's how I want the assets distributed, right? The way to avoid probate court is by having a trust, right? Having those assets in a trust would then avoid probate court. The other thing that I want to mention about having a will is, I said, having a will, or a will is filed when somebody passes away, which means if somebody is healthy or if somebody is sick while they are alive, the will does nothing, right? A will doesn't give you any type of ability to act as an agent. I had a guy that called in and his dad had dementia, and he had done a DIY plan online for him, and he got him a will. And he called in and he said, my dad has dementia. I need to sell his house to put him in a home, and but I have a will saying that I'm his agent to act. And I asked him if he had any other documents, and he said no, they only got the will. And I said, unfortunately, a will alone is not going to allow you to sell dad's house. A will only comes into play when dad dies. I'm like, at this point, you needed the house in a trust and having that trust document, or at least a power of attorney. And that power of attorney would have given you the ability to sign as dad's agent. But a will alone is not going to be able to do what you need it to do. So in that case, and in so many cases that I see where people just go and do things online and they have no input as to why, and no conversations with attorneys as to the reason that things are needed. They just have this idea and they go and they do it online. He had to get a conservatorship. And so that was something that ended up costing $6,000 to $10,000 for a court conservatorship. Whereas if they had just done an estate plan that was comprehensive in the beginning, it would have saved them a lot of money, Okay, a few questions that have come in. Is a healthcare directive automatically included in the trust? No, it is not. If you have a trust, these are all separate documents that are in addition to having a trust. So our estate plans that we do comprehensive estate plans. They come with a lot of different documents. And one of the documents that we include in our estate planning package is an advanced healthcare with that trust. Okay, next question. Do you still need a will if you have a trust? Great question. And that'll transition me to my next one, is talking about trusts. So, and I'll come back to that just as soon as I explain what a trust is. So when we talk about trust, we're talking about revocable living trust, or a revocable trust, or a living trust, or just a trust. These are all interchangeable terms. They all mean the same thing. A trust is an agreement, and it is an agreement between the grantor, which is the creator of the trust. They put specific instructions in writing to the trustee. Now, the trustee is the person who agrees to hold legal title to all of the assets in your trust, and they will follow the instructions in your trust for your beneficiaries. So 3 terms I just threw at you: grantor, trustee, and beneficiary. While you are alive and you have a revocable living trust, you are all 3 of these roles. You are the grantor, meaning you create it. You are the trustee, meaning you hold title as trustee to all of the assets in your trust. And you are the beneficiary. While you are alive, the assets are in your trust are all there for your benefit. You're not losing any control to the assets in your revocable living trust. The other thing that I'll mention about trust is people think that, I don't have an estate. I had some guy tell me that before. I don't need a trust, or I'm not Bill Gates level, right? I don't have that type of money. And in the examples that I gave in the beginning, where it was mom, all she owned was a home, right? That was the only thing, and that had to go through probate. That's the perfect example of where a trust plan would come in, especially in California, where our probate process is very long, to avoid having to go through it, right? To avoid having to spend all that money, to avoid the time it takes. And so, and that was an average home that could have been avoided having to go through probate court had it been a trust. Okay. So for the question about, do you need a will if you have a trust? So great question. And yes, you would need both. And the reason for this is we're going to create a trust, and then you're also going to create what we would call a pour over will. And that pour over will is not going to have any information about how your assets are going to be distributed. It's going to say is that if anything gets left outside of my trust, it just gets poured over into my trust. And so when you have a pour over will like that, if something got left outside of the trust, like a bank account, some assets for whatever reason, then instead of having to go through a full probate, it's just a shortened petition that would need to get filed with the court to get it put into the trust. And what that does is then it keeps your assets private. It makes sure that nobody really knows the personal information about who's receiving what, because that's all in the trust and that doesn't get filed with the court. Okay. So yes, having a pour over will or a will and a trust that work together. Do we do estate plans if I live in Georgia? I am sorry, but we do not. We are licensed in the state of California. However, I do work with attorneys all over the country. So if you need an estate plan in a different state, please feel free to reach out to us and we can get that contact information for those other attorneys in the state where you're located. Always best to work with an attorney that is in the state that you are located. And if it looks like you lived in California and now live in Georgia, so you can take that California trust that you have to the Georgia attorney and just see if there's updates that need to be made pursuant to Georgia law, right? Same thing for anybody else who may have had a trust somewhere else. Sometimes the laws are different in other states. I had a client who I think she was in Montana when she passed away, and daughter lived here. So we were administering, and mom had moved here too. This is where she had died, was in California, but she had done her estate plan in, I believe it was Montana. And so we were going through her estate plan, and unfortunately she never had it updated when she moved out here. And so it was still valid according to Montana law, but not California. And the will was not valid because it was notarized. And in California, we require two different witnesses. So two witnesses to be able to make a will valid. And so we had to go through a different process where the will was not valid because it had never been updated. Okay. So some of the benefits of having a trust. A trust allows you to set up sub-trusts for your children to be dispersed at ages you set, maybe 25, 30, 35. Again, you're the creator of your trust. You choose the ages that you would want, but it does provide some flexibility to make sure those assets can stay protected. Trust can help protect your children's inheritance from predators, creditors, and divorce, maybe remarriage, trying to prevent any of that blended family situation from coming in. When you have a trust, you get to choose the trustee that's going to be in charge of the finances. So maybe there are people that, if you have minor children, maybe the guardians for your minor children, you would want to be trustee, but you don't have to. Maybe you have adult children and you would want them to be the trustees or the backup trustees. We call them successor trustees. Some people know them as executors. There's different names for them, but that's your choice, right? When you have a trust, it's private, so no court involvement, which means less money that's being spent. When you have a trust, and especially if you have minor children, a trust will allow you to list beneficiary designation on like a life insurance policy to the trust. And so that way, if something were to happen to you, instead of that money going to your kids, which they can't actually inherit if they're under 18, it has to go through court. But if you had a trust, you could say, well, I would want that money going to my trust, where then my kids would be able to access the money and then get percentages of it at 25, 30, 35, right? And so there's a lot more flexibility when it comes to having a trust, okay? A question came in, can a trustee live in a different state? Yes, a trustee can live in a different state. The only requirement when completing or when figuring out who your trustee is going to be is that they are over the age of 18 and a U.S. citizen. Those are the two requirements for being a trustee, okay? Okay, here is a diagram of a trust, just to kind of give you again kind of what that flow looks like if you're more of a visual learner, with the different assets pointing to the trust or in the name of the trust, and how the assets are then distributed to the beneficiaries. Okay, last one we're going to talk about is guardian nomination, and then we are going to start wrapping up and I will take more questions. So long-term guardians. So you want to choose a guardian that, again, children under the age of 18, you want to choose a guardian that's going to share the same parenting style as you, right? They have the same values. They will provide the best love, education, and support for your kids. You are the best parent for your child. But if something happened and you weren't able to be there, who would you want in that role? I know as a mom with young kids, this is the hardest part of estate planning. You never want to think about not being there for your kids. But without having a plan in place, without going through this process and identifying who those guardians are, then if something were to happen, the court has no idea who you'd want in this role. And what that also means is that the court has no idea who you would never want to raise your kids. And so having guardian nominations is so important. When we look at guardians, we also look at short-term guardians. So who within 30 minutes can be to the kids if there's some type of emergency, right? If you and your spouse are out on date night and there's an accident, the kids can't stay with a babysitter. Who would you give legal authority to be able to keep them? What the goal here is to try and prevent Child Protective Services from coming into the home, removing the kids and putting them in foster care. Okay, by having it identified and having those people know, hey, you're a short-term guardian, because maybe the guardians that you have are in a different state. Maybe they're across the country. Maybe they're in a different country. We've had that happen before. And so it's important to be able to have that backup plan. Without your guardian nomination, a judge, again, would have no idea who you would want to be there for your children. Okay? Okay. So again, I talked about that complete estate plan, that comprehensive plan. So it's not just one document, it's many documents. Guardian nomination, power of attorney, a will, a trust, healthcare directive, HIPAA authorization. Those are like the basic complete estate planning documents that you need, right? Every plan should have at least these documents. If you don't have minor children, obviously not going to have the guardian nomination, but everything else would be in there, okay? Okay, so after hearing all of this, do you think you might need some type of estate planning? Yes, right? Anybody over the age of 18, but especially if you have minor children and or own a home, you need some type of estate planning documents. Okay, so I'm going to talk about the services that we help you with to make sure that you can put your plans in place to make sure that your wishes are known, giving you the peace of mind that you deserve. Okay, so our basic trust package comes with a basic revocable living trust, pour-over will, power of attorney, advanced healthcare directive, HIPAA authorization, trust certification, estate planning summary, general assignment, personal property memorandum, memorial instructions and funeral wishes, and trust funding toolkit. In addition, it also comes with 2 virtual meetings with our attorney, phone, portal, and email support from our team. If you have a primary residence in California, we're going to get that primary residence transferred to your trust, which is, one of the biggest assets that a lot of our clients have. We want to make sure that it gets put in your trust properly. We're also going to prepare the assessor's office form that goes with it, and you have those recording done. There's no additional fees for that. That's all included in that cost. The documents would be signed. We have a virtual notarization that we would have done. All of the documents are sent to you in a portfolio. We're going to provide you a USB drive. The USB drive has, I think I have one here. It has all of your documents digitized, right? So that they're all in a PDF, so that if you ever needed to buy another home in the future, you can send your certificate of trust directly to the title company, and then keeping your documents up in the cloud so that you have them somewhere safe. So you're going to get all of those on a scan. You're going to get a trust funding toolkit as well as access to any of our other workshops or events that we have. Okay, so let's talk about how much estate planning costs. So everything that we do from an estate planning perspective is done as a flat fee. So our trust packages start at $4,495 for a single person and $4,995 for a married couple. For coming to this workshop today, there is that discount of $500 off that trust package, which means you can get a trust if you are single for $3,995, and if you are married, it's $4,495. Okay. Okay. Let's talk about, as we wrap up here, just kind of 2 different scenarios. And remember how I asked you to think about what is your asset level at? Because I want you to think about, by not having an estate plan in place, what is the cost that my estate would have to pay if the situation came up? So again, that estate plan range of about $4,000. Okay, so what if you were to get sick? The documents that your family would need if you were to get sick are a power of attorney, an advanced healthcare directive, and a trust, right? Those are the 3 if you were to get sick. Without having those documents done, without paying that $4,000 today, then your estate would have to pay somewhere around probably $6,000 to $10,000 to go through the court conservatorship process, right? That's how much the court is going to be, with attorney's fees and filing fees and some other fees that are associated with it. This can be avoided by having your estate plan done now. It can be avoided having to get that conservatorship in the future. Okay. Let's talk about if you were to die and what your estate is worth. So this is again where I wanted you to think about, what is the value of your estate? If you have a home, what is that fair market value? For paying that $4,000 for an estate planning package, the statutory fees for a $600,000 estate would be $30,000. An $800,000 estate would be $38,000. A $1 million estate would be $46,000. $1.2 million would be $50,000. And $1.5 million estate would be $56,000. Like, these are huge prices, right? Huge costs that would have to be paid by the estate for the estate to have to go through probate. And it doesn't just stop at 1.5, right? It continues going on, but I've run out of space on my screen to be able to continue doing it. $1.5 million in California, that could be a primary residence and a rental home, $56,000. But what I'm also seeing is that when somebody passes away and they do not have an estate plan in place, the families can't afford these fees. And so they're actually having to sell the property that they were planning to live in with their family because they can't afford the fees to have to go through probate court. So wouldn't paying that $4,000 now to be able to prevent having to pay $50,000 out of the estate later seem reasonable? It is, right? But it's not just the money. Think about what estate planning does. Estate planning is a plan that allows you to say, if something were to happen to me, here are people that can make decisions and know what I want. I had a client that called me, and it was, I'll never forget this call. She says, I'm so angry at my mom. I'm so angry that my mom just died, and I have to make all these decisions and do all this paperwork that I can't just be sad that my mom just died. Right? And that is what estate planning does, is it takes the burden off of your loved ones. It takes the burden off of those that are going to have to make those decisions, that are going to have to do stuff for you. It helps lighten the things that they're going to need to do as a result of your passing, right? As a result of you getting sick. And so it gives you that peace of mind to know, and I hear this from people all the time. When they get their last document signed, they just say, I feel so grateful. I feel such peace of mind, like this weight has been lifted off. And that's really what estate planning does, is it makes it easier for those that have to be in those positions. Okay. I do see some questions that have come in, so I'm going to get to those. I do want to go real quick through our process with you on moving forward and what that is. So our estate planning process, the first thing that you're going to do is book a family planning appointment. We will send you an email where you'll complete an online worksheet and get that submitted. Our next meeting that we would have with you is with one of the attorneys, will be that virtual family planning appointment. During that meeting, the attorney will design a plan to fit your family's needs, to ensure that your wishes are documented, giving you that peace of mind that you deserve. Generally, the estate planning process takes about 4 to 6 weeks. So from this time you have that first meeting with the attorney until the time you sign your documents, it's about 4 to 6 weeks. Okay. Next. To get the webinar discount. So that $500 off, you are going to book a family planning appointment. And that's going to need to get scheduled within the next 3 days. Okay. I'm going to put the link in here to be able to get that appointment booked. You will also get an email with the link to be able to get that scheduled. The family planning appointment needs to take place sometime probably within the next 2 weeks or so, depending on availability. In addition, once you get that appointment booked, you are going to pay the non-refundable $349 FPA fee. So this fee is not in addition to what I quoted you for an estate planning package. This $349 will just get applied to the balance. So then when you meet with the attorney, you're going to owe less money than that $4,000 or the $39.95 or the $44.95, depending on what your plan is. Okay. So it's not in addition to it. It does come out of that cost. But both of those things need to be done for you to get that $500 discount. I did put the link in there for you to be able to book that family planning appointment with the attorney. Okay. If you found value in this webinar, I would greatly appreciate you leaving us an online review. It just helps other people really get an idea of what they're going to find when they come to our webinars. And it really shares your experience so that they hopefully think it won't be as bad as what they think estate planning is going to be. But I would greatly appreciate it. Okay. Keep us in mind, again, this is for California. Other things that we help with, not just the estate planning side, but if somebody were to pass away, right? If there's probate court, trust administration, sometimes there's property issues after somebody passes away. They're not really sure what to do. Please send them our way, as these are other things that we do help provide services for. Okay, if you are ready to book your family planning appointment and design that plan to fit your family's needs, please make sure to click on that link to be able to get that family planning appointment scheduled. And then at this point, I am going to start taking some questions. I did see a few come in. Oh, and the free advanced healthcare directive, I'm sorry. So to download your free advanced healthcare directive, I'm going to put that link in there. So make sure, again, this is for California specific. So make sure to download that, go get it, have it filled out, get it signed. And then you know, at least from a healthcare perspective, you've got some stuff documented until you get your plan done. Okay. So now I'm going to go through questions. And if you don't already, please make sure to follow me on Instagram. It's at Estate Planning Mom. And I want to say thank you for joining me today. And we're going to get to questions. Okay. After you have a trust, should everything you purchase afterward, vehicles, parentheses, be purchased under the trust? So I wouldn't say everything. It just depends on what the asset is. It also depends on what your strategy is when it comes to your assets, how you want those distributed. Other things to take into consideration is how old your beneficiaries are. So just to give you a few examples, if you have a primary residence, most likely your house is going to be in the name of your trust. If you purchase a house in the future and you want it in your trust, you can provide your certificate of trust directly to the escrow company or title company, and they will title it directly into your trust as you're completing that purchase. If you go to sell your property in the future, you just sign it as the trustee of your trust, right? You don't have to come back to us or do anything like that. Vehicles, generally we do not recommend putting your vehicles in the name of your trust. Bank accounts, so if you have checking, savings accounts, putting those in the name of your trust. Investment accounts, those can be put in the name of your trust. Retirement accounts, there is some tax strategy that has to go along with that. Generally, we look at who are the beneficiaries that are receiving. If it's going to adult children, then I wouldn't recommend putting it into the trust because they're probably going to get a better tax basis by having them listed directly as the beneficiaries rather than it going through the trust. So there's a lot of things to take into consider. This is where working with an attorney to understand what assets need to go where is really important. This is something that we do with our clients in one of the meetings, the second meeting we have with the client. When we review documents, review who's in their plan, we're going to talk about funding their trust, right? What assets need to be changed or beneficiary designations. I hope that helped. Okay, if you have any questions, again, please put those in. If you have not already booked your family planning appointment to get started, please click the link to be able to get that appointment scheduled. And then I saw another question come in here. Are the beneficiaries protected from creditors? Can you give me any more information on the beneficiaries? Or is it the beneficiaries of the trust? Is it your creditors? Is it their creditors? So there's a couple different ways to look at it. Oh, thank you, Karen. I'm glad you enjoyed it. Again, if you are ready to leave, please feel free to leave. If you don't have any other questions, please make sure to click that link to get your appointment scheduled. And again, you should get an email with the information. So I don't see a response to that one. So all I'm going to say is for the the creditor issue, because I don't see a response, I'm going to assume that it's beneficiaries of a trust and it's their creditors. So I'll make that assumption just to be able to answer this question. If the assets that are from a trust are to the beneficiary and they haven't received them, they are still in the trust, then generally, yes, those assets are going to be protected from creditors because the beneficiaries don't have access to it, right? They can't just go withdraw the money, right? And so generally it would be protected. Okay, those are all the questions that I see. Thank you again for joining me today, and I hope you have a wonderful day. Thank you.